reporters continue entering the session, we wanted to let you know the conclusion of the remarks. We'll have a few minutes for questions. Reporters can click the raise hand button on the screen to indicate their interest in asking a question, and they will be called on and unmuted. Without further delay, turn it over to Attorney General Matt Platkin.
Thanks, everyone. I want to thank my colleagues, Attorney General Nick Brown of Washington, Attorney General Rob Bonta of California, Attorney General Andrea Campbell of Massachusetts, and Attorney General William Tong of Connecticut, as well as all of the attorneys general in our coalition across the country for both joining us today and for litigating this very important case. The first day of the Trump administration, President Trump signed one of the most blatantly unconstitutional orders ever signed by a president, attempting to strip birthright citizenship out of the United States Constitution for the first time since the United States Civil War 157 years ago. I want to be clear about what the court did not do today, notwithstanding that I have strong disagreements with what the court did. And I note it chose not to address the issue of universal injunctions for the duration of the time that they were granting them for Biden administration appointee orders, and chose on the first order that got up during the Trump administration to use this opportunity to issue this decision. Putting that aside, I want to be clear about what the court did not do today. The court very clearly did not address the merits of birthright citizenship, and they in fact stayed the executive order for another 30 days for everyone. So let's be clear. Birthright citizenship remains the law of the land in states like New Jersey and in every state across the country. It also said very clearly that it leaves open to the district court whether or not nationwide injunction is necessary to give states complete relief, something that we argued as a coalition at every level, including at the United States Supreme Court, where we said very clearly that in order for states to receive the protections we need from the harms inflicted by this order, we need nationwide relief. Because if you think about very obviously, people born in states that are not part of our coalition might move into our state, and the federal government has not shown in any way how we could possibly administer a system of citizenship and the benefits that flow from it without having one standard of citizenship under birthright citizenship in every state. We are very confident that we have met that standard. We are confident we will meet it when we go back to the district court, and we are grateful that the Supreme Court left open our rights to seek that relief as this case goes forward. But make no mistake, birthright citizenship is in our United States Constitution for a reason. We fought a civil war to address whether babies born on United States soil are in fact citizens of this country. For a century and a half, this has not been in dispute. And we are confident that as we litigate this case, that fact will remain, and we will never stop fighting for people's rights in our states and in states across the country when it comes to the 14th Amendment of the United States Constitution. So I thank you all for being here. It's now my honor to turn the mic over to Attorney General Nick Brown from the state of Washington.
Thank you, AG Platkin, and good morning, everyone. Honored to be joined with my colleagues today. I will echo what my colleague from New Jersey just highlighted, that on the one hand, this is an incredibly disappointing result. I think the Supreme Court had the opportunity to provide clarity for the entire nation, to reaffirm what has been the law of this land for over 150 years, and missed that opportunity with this order this morning. But what the court did not do was negate any of the substantive arguments that the states made in bringing challenges to this blatantly unconstitutional executive order. The court did not address the 4 district court decisions, each of which independently found that this was an unconstitutional order. And we remain confident that we will prevail as we continue to litigate these issues forward. But this is a disappointing result. And I'm really struck by some of the language highlighted by Justice Sotomayor in her dissent, noting how fragile the rule of law is in America today and how the court made it even more tenuous in this moment. But we will not give up. We will continue to fight. It takes actors willing to challenge abuses from the highest levels of the land. And that is what we're seeing from this president of the United States, where time and time again, he is undermining the rule of law, undermining state sovereignty, undermining the separation of powers. And it is incumbent upon all of us to not capitulate in this moment, to not accept these changes that we're seeing from the president and the rest of the administration, and continue to use every tool that we have available to challenge these unconstitutional orders. But I am confident as we move forward that the court will see what all of the other courts have seen, that we cannot accept a blatant changing of our Constitution with the stroke of an executive order. That is not the way this works, and we will continue to defend the rights and liberties of everyone in the United States because we need to stand up in this moment. But it requires a lot of collaboration with, and I'm so happy to be joined this morning by all of my colleagues, and I will turn to my colleague from Massachusetts, Andrea Campbell. Thank you.
Thank you, AG Brown. I too am grateful for the partnership and collaboration of my colleagues on the screen and those who couldn't join us today for their leadership on this issue. Because what we all know to be true is that birthright citizenship is a constitutional right enshrined in the 14th Amendment. And for more than a century, the 14th Amendment has defined birthright citizenship as a right, not a privilege, that belongs to every child born on American soil, no matter the parent's immigration status or what state they were born in. Millions of Americans can trace their citizenship back to immigrant ancestors who helped build this country, fuel our economy under the protections of the 14th Amendment. And the 14th Amendment is just as strong today as it was when it was enacted more than 150 years ago. And it states clearly that the president's executive order is unconstitutional. That executive order is not in effect today, even after the Supreme Court decision, which is disappointing to all of us. And we have every expectation that we will absolutely be successful in keeping the 14th Amendment as the law of the land, and of course, birthright citizenship as well. We are deeply disappointed that the court did not decide today that a nationwide injunction is warranted, so that no matter where in the United States a baby is born, that baby will continue to be a citizen. Instead, the court asked the plaintiff states to demonstrate the need for a nationwide injunction in the district court. We have already done that, and we look forward to doing that again. Citizenship does not depend on whether a baby is born in New Hampshire or in Massachusetts. People move, they live along state borders, they're born in hospitals outside the state they live in. A baby's citizenship should not, cannot, and must not be determined by the borders of the state they find themselves in at the time of birth. And that's why the district court initially granted nationwide relief, because they understood that to be true. But let's focus on the bottom line. While we're absolutely disappointed that the Supreme Court did not take up the issues that really needed to be taken up and discussed, we are in court to strike down this sham of an executive order and to protect more than 150,000 babies born in the United States every year, whom the president has attempted to strip away their citizenship. We intend to be successful, and today's decision is now just another procedural hurdle that we will have to overcome. And we also have to remind folks that this is a democracy, and we all learned in elementary school that if you want to amend the Constitution, there is a well-established process to do that. It requires, at a minimum, Congress and the approval of 38 states. And the president cannot change the 14th Amendment or the Constitution on his own with the simple strike of a pen. So while we remain disappointed, we take that disappointment forward, and the work continues to win this case and to defend the rights of every child born in this country and to uphold our history and our Constitution. And I'm confident that in these tasks, we will absolutely succeed. Thank you again to my colleagues, and I'm proud to turn it over now to Connecticut Attorney General William Tong. You have to unmute, I think, AG Tong.
Okay, thank you. It's only been several years with the muting and unmuting, but I'll get it at some point. I think I'm supposed to turn it to General Bonta actually before he turns it to me. So let me go to California from Connecticut.
My apologies, AG Bonta. Proud to work with you too.
You're very, very kind, both of you. I appreciate the opportunity, and grateful always to be with you, to work with you, to fight with you for the rule of law, to defend our Constitution. And thank you, AG Tong. Thank you, AG Campbell. And thank you to everyone who's joining us virtually today. Today's Supreme Court decision is definitely a mixed bag with some disappointing components, but also some signs of hope. And first and foremost, birthright citizenship stands for now. And the Supreme Court recognize that our injunction may be justified if its nationwide scope is necessary to afford the states complete relief. And it's now up to the lower courts to reconsider if the nationwide injunction is appropriate and necessary to provide complete relief to the states whose AGs sued to challenge this order. We believe that we will prevail and that we've made the case already. And when the lower courts, under the instruction of the U.S. Supreme Court, do that review, we will secure a nationwide injunction to provide relief to the plaintiff states. I'm hopeful that the court will see that a patchwork of state injunctions where birthright citizenship stands for some states but not others would inevitably create administrative chaos, sparking widespread confusion and spurring questions we don't have the answers to. The rights guaranteed by the U.S. Constitution, they belong to everyone in this country, not just those whose state attorneys general have the courage to stand up to this president's anti-democratic agenda. The Supreme Court's decision today is not what we hoped for, but you can be sure the fight is far from over. The court didn't decide our birthright case today. Our case is continuing to make its way through the legal system and will continue to show up every step of the way to fight for the rights of all Americans born in this country, regardless of where their parents are from. We believe our case is clear because the law is clear. The 14th Amendment of the Constitution and the Immigration and Nationality Act are clear. Birthright citizenship is foundational to our history and has already been upheld by the U.S. Supreme Court. One such case centered around a San Francisco-born Chinese-American man named Wong Kim Ark, who successfully sued the U.S. when he was denied entry back into his own country after visiting family in China. Officials wrongly claimed he wasn't a citizen. In 1898, the Supreme Court affirmed that children born to immigrants in the U.S. like Ark couldn't be denied citizenship. As our case continues, you can be sure that my colleagues and I will be here every step of the way, fighting to uphold and protect the constitutional right to birthright citizenship. I'll be here fighting to safeguard the tens of thousands of babies born in California each year who should rightfully be citizens. We're a nation of immigrants. It's our legacy and it's our identity, especially here in California, home to more immigrants than any other state, including my own mom who immigrated from the Philippines. Our diversity is both our story and it's our strength. I'll always defend it. I'll always stand up for all of our diverse communities who make California and America great. I'll always hold those who break the law and violate the Constitution accountable, including the president. And before I close, I want to again acknowledge the great work done on this case by our respective teams, the AGs on this press conference call, as well as our staffs and our colleagues from around the country. We couldn't do this work without our great teams. And at the California DOJ, that includes Irina Trasovan, Marissa Malouf, Christopher Hu, Denise Levy, Delbert Tran, Lorraine Lopez, and Annabelle Wilmot. I want to say your names and recognize you and thank you for the incredible work that you do. You are incredible, dedicated public servants, each and every one of you. I'm proud to stand by your side and be on your team. With that, please allow me to turn it over to my friend and colleague from the great state of Connecticut, AG Tong.
Thank you, General Bonta. And let me thank my colleagues. Let me thank New Jersey, Washington State, Massachusetts, California, all of their staffs, all the states in our coalition. I don't think there is a group of people, Americans, who are fighting harder as a group, as a coalition, than we are to protect the American people and to be a firewall for our states and for every state and everyone in this country. As General Platkin said, the 14th Amendment is strong, alive, and well, and birthright citizenship remains at this moment the law of the land. It's the law of the land because we acted, but it's also the law of the land because the 14th Amendment means what it says. If you're born on American soil, you're an American, period. And the Supreme Court affirmed that principle more than 100 years ago in San Francisco in the case of Wong Kim Ark. I'm here this morning not just because I'm an attorney general and I represent the great state of Connecticut, but because I too am Wong Kim Ark. There are millions of Americans who share Wong Kim Ark's story. There are millions, thousands of American babies who are being born, about to be born, were just born, who are also Wong Kim Ark. There are so many of us that share and embody the truth of Wong Kim Ark and his story, that the 14th Amendment confers citizenship on us, that we don't derive our citizenship from our parents. We derive our citizenship by operation of the 14th Amendment and the Bill of Rights and the United States Constitution. This is the most solemn, sacred guarantee covenant that this country makes to the people that live here, to Americans, to people born here in American soil, and that's what we're fighting for. I also want to just put in perspective what this means. We've talked a lot about the rule of law. We've talked about the constitutional crisis that we're in. We've talked about the 14th Amendment and how the Constitution works. But at the end of the day, this is about real people. It's about families. It's about children. It's about babies. And I want to take you back 52 years ago, when I was born in Hartford, Connecticut. I became the first American citizen in my immediate family by right of my birth in Hartford Hospital on American soil. So let's fast forward to 2025. What if William Tong or Wong Kim Ark or any of the millions of Americans like us were born now, today, or 30 days from now, when this court order takes effect? What would that mean for us? Well, right now in Connecticut and in the sister states that were part of this coalition, frankly, in every state right now, it means I'm an American citizen. If I'm born a minute from now in Connecticut and anywhere in this country, I'm an American citizen. But there is already considerable uncertainty because the court said, well, in 30 days, we'll be in a different place. And it's not clear what will happen after those 30 days in states like Texas, Louisiana, Pennsylvania, who weren't part of our case. So even if there's a family here in Connecticut and a baby is born a minute from now, and that baby is an American citizen in Connecticut, how will they be regarded in other states? And let's fast forward to 30 days from now. We're going to go into court and we're going to fight hard. And I believe within the next 30 days, we're going to get more clarity and we're going to prevail. But in 30 days, if that's not the case and we still have uncertainty, if I'm born in Connecticut, yes, the injunction still applies to me. Birthright citizenship is still the law of the land in Connecticut. But what about in Pennsylvania? What about in Texas? What if a pregnant woman in Connecticut goes to Texas, goes to Pennsylvania, goes to Louisiana, goes to Utah, and has the baby there? Then what happens? As General Campbell said, what if they're right over the border? What if they live on the border? What if they live in another jurisdiction close to where they live? They go over there to go to work. They go over there to visit family. They go over the border to go to school. And they need to go to hospital and have the baby right there and then before they can go back to their home state. And ultimately, what does this mean for families and the decisions that they make every single day? You know, my parents knew when I was born that I was an American citizen. They had that certainty. It was clear to them, period, full stop. And because of that, they knew they could make all the investments that they made in me and later my sisters, that they could put everything, their heart and soul, into us as Americans growing up here in Connecticut. You know, would my parents have opened another restaurant? Would they have bought a house? Would they have hired more workers? Would they have signed a lease? Would they have invested all the resources they've invested in my education and my sister's education? Would they have made all of those choices without the certainty of my citizenship? That's what this means for American families, not just in our states, but in every state. They need that certainty that the 14th Amendment guarantees so that they can build a life for themselves in this country and for their children, and do what my family and Rob's family and so many immigrant families have done for generations. Built this country into the most just, most powerful, most economically prosperous, most free country on earth. That's what we're fighting for. And that's where we're going to continue in this fight, and that's where we're going to win. Thank you. Let me turn it back to General Plotkin.
Thank you, General Tong. Thanks. I'll turn it over for questions in just 1 second. I just want to make two quick concluding points. First, I want to thank all of the AGs on this call, their teams, and the AGs across the country who have stood up. I also want to give a particular thanks to our Solicitor General, Jeremy Feigenbaum, who argued the case, as well as our whole team in our office who have worked on this for a very long time, which gets to my second point. One thing the Supreme Court said quite clearly today is state attorneys general have never been more important. We are, in fact, the only parties that they kicked the case back to the district court because they felt our relief could not be granted potentially without nationwide relief, which we will show. But it means the work that we're doing is all the more important. And I'd highlight that this case that we all filed was filed the very next morning after this unconstitutional order was signed. We were prepared. We knew this would be a fight, but it's a fight worth having. And I'm proud to be a part of this coalition. And I assure you, as I know I speak for the entire AG coalition in this case, we will not stop fighting for the people in our states and the people of this country. I'm now happy to open the floor to some questions.
You. We'll turn to the Q&A now. Reporters, some have already clicked the raise hand button on the screen, and then we'll call on you and unmute you. We'd ask that you keep the questions concise and on topic. We'll go a few minutes past 12, and we'll see how many we get to. If we don't get to your question, please follow up with the individual Attorney General office that you're interested in. So first we'll call on Zach Blackburn at New Jersey Globe.
Hi, my question's for Attorney General Platkin. I understand that the door is still open for nationwide injunctions under complete relief, and that'll come in future proceedings. But can you talk about your understanding of how this ruling changes the threshold needed to justify a nationwide injunction, as well as what new limits have been placed on injunctions, how they can be implemented, and how that relates to this case? Thank you.
Well, look, for states, it's consistent with what we've argued all along, which is that in order to remedy the harms this order would impose on us, we need nationwide relief. Because, and Zach, you're here in New Jersey. Take Philadelphia. People born there very often live in New Jersey or shortly thereafter move to New Jersey. The federal government has made no attempt to show how we could possibly administer a system of citizenship where states and benefits and rights flow from whether or not somebody moves into a state, who their attorney general was at the time of birth, what happens if they move in and move out. There's all kinds of administration challenges, which is why we need nationwide relief and one standard of citizenship, which again, we have had since the Civil War. So we're not exactly asking for, something insane here. And I'm confident that as it goes back to the district court, as we have shown at the district court, at the circuit court, at the United States Supreme Court, we will prevail on that front.
From John Stang.
Hi, I've got two questions. First, what do you think? What is the expected timetable for the entire Fourth Amendment issue to actually reach the Supreme Court? Is this 1 or 2 years down the road or 6 months down the road? And then the second question is specifically for AG Brown, very parochial. I just want to confirm that the injunction against Trump's executive order is still in place for Washington State.
So happy to take this question, John. First and foremost, none of us can predict the timing of the Supreme Court. It is never wholly consistent, so we'll just take one step at a time. As AG Platkin and others have noted, the order stayed for 30 days. The Supreme Court directed this to return to the lower courts. It's not necessarily a given, actually, that it'll go to the district court, but they could have done that in the first instance, but did not. But we can't really predict the timing. But yes, the injunction is in place now for Washington and the other states, and we'll just take one step at a time as we move forward. The other thing that I would just note is, there's good language in Justice Sotomayor's defense talking about and noting the fact that every single district court that has looked at this issue, specifically determined that there was a need for a nationwide injunction. And, we expect that pattern to continue as we move forward. And as AG Plotkin highlighted, it's really, really difficult to imagine that the Department of Justice and the administration can justify and explain how this would be administered on a state-by-state basis. It's practically impossible to do that, and we feel confident that each district court will continue to affirm that.
Thank you. NBC Boston, Oscar Margon.
Hi there. Thank you so much. This is a question for everybody, of course, but because we're in Boston, more specifically for AG Campbell. And you guys have already sort of answered this in a way, but if you could just clarify what the next step will be with regards to this suit. Does it mean you have to refile it with the lower courts? And then what happens in the meantime with the birthright citizenship in all of these states? And I think that question was already answered, saying, tell me if I'm wrong, that the injunction prevails here, and so there's no change with that, correct?
That is correct. The executive order will not go in effect here in Massachusetts, and we will return to court to revisit, frankly, and urge Judge Sorokin, who drafted an incredible decision with respect to this case, to enter an injunction with the same scope as the previous order that he entered. And I think, AG Brown, AG Plotkin, and others have said it. Every single court that has weighed in on this issue has said not only is birthright citizenship the law of the land, but made it crystal clear that nationwide relief and a nationwide injunction is absolutely necessary in order to make sure that actually happens in actuality for families and, of course, for parents and others, and to make sure that clarity is made and to ensure that clarity exists as well. So, of course, while the order may not be in effect in Massachusetts and will not go in effect in Massachusetts in 30 days, we want to also continue to join colleagues all across this country to ensure that it never goes into effect anywhere.
If I can just note also, one of the reasons I hesitate to get in the minds of the Supreme Court, but one of the reasons why they had to send it back to district court is because at the district court level, when we were first there before Judge Sorokin, the federal government didn't even try to say what alternatives could exist that would allow states to administer this. So in order for them to assess whether we need nationwide relief, which we do, which we've argued, the federal government has to show what alternatives exist, and we'll be able to show very clearly that those will not work in order to provide us the relief that we're entitled to.
Question from Oriana Gonzalez at Notice.
Hi, thank you so much. I guess, you mentioned at the beginning that collaboration, is key when we're talking about Democratic AGs and how they challenge Trump and his executive orders. But it's not like we see, all, I believe, 24 Democratic AGs joining one lawsuit at once. So with what we're seeing with nationwide injunctions today, does this raise the pressure for all Democratic attorneys general to become involved in each lawsuit that is challenging Trump's executive orders and his policies?
Look, I think you've seen over the past 5+ months incredible coordination and collaboration among states. States sometimes have individual circumstances that assess particular cases. I think the better question we should be asking is the states that haven't joined any of the suits, why they don't think babies born in their state are entitled to the protections of the 14th Amendment, why they don't think that universities in their state should be able to administer cancer and Alzheimer's trials, why they don't think people on Medicaid in their state should get the health care they're legally entitled to, why they don't think law enforcement in their state shouldn't be unceremoniously fired. All of those things have been addressed by our suits, and yet there are some states that haven't joined a single one of them. So I'm proud of the coalition we have, but I think that question really should be directed at states that are, I think, going to be on the hot seat now after today's opinion.
And I'll just add, go ahead, AG Bonta. I'll just quickly add to Matt's point. I'm really proud to be a part of this AG and, of course, Democratic AG coalition that is doing the work every single day to protect our rights and, most importantly, the rule of law. And we can't take our sight off of that. Regardless of how you feel about the 14th Amendment, I tell folks, pick the amendment you like, the first, the second, whatever it is. And if we allow the president to use an executive order to dismantle the 14th Amendment, he can then do that with respect to any other amendment, all of which we have been saying from the very beginning is unconstitutional and that he does not have the authority and the power to do that via an executive order. And so the question does remain, why are Republican AGs, to be explicit, not a part of these lawsuits that are blatantly violating the Constitution and blatantly outside of the authority that the president has?
I do want to just double click on your point about collaboration. It's been critical. It's important. It remains so. This group here, I couldn't be more proud to serve with and have been working with for over a year now to prepare for these lawsuits in this moment. And our role is as important as ever. In many of our cases, all of our cases, each state makes a decision that's best for their state. That will continue, whether they join the suit or not. And in this case, every single Democratic AG is participating across the two lawsuits that we've brought. But the point that AG Platkin makes around and I'll just be clear about who they are, because this is factually accurate, that the red state AGs are not fighting for the rights of their people. They're not protecting the funding that's being unlawfully and unconstitutionally withheld by the federal government that should go to their states. And I honestly have thought that during the course of our lawsuits, they have been secretly very happy that we're suing, because they have been coasting, drafting behind our work and benefiting from it without having to do the work. That is potentially no longer the case in some instances, depending on what is an appropriate injunction for the plaintiff states. So I believe they've always had important questions that they need to answer from their constituents about why they're letting their constituents' rights be trampled on, why they're letting the critical, essential funding for healthcare and education and NIH funding and other critical services get withheld unlawfully by the president and just laying down and doing nothing. And those questions from their constituents are only going to get louder now.
Thank you. We're going to try to squeeze in one or two more. We're a little bit past our expected time here, but maybe Zoe Tillman of Bloomberg News.
This, and this is for any of the attorneys general. First, can you address whether you see this as putting any existing injunctions with nationwide scope in other cases in jeopardy? So any kind of retroactive concerns about cases where you've prevailed, or just generally, do you see this as having backward-looking consequences? And then looking forward to future litigation, how do you see this as changing the strategy or what you need to show to get nationwide relief now?
Look, I think as states, we've always said nationwide relief should be limited, or should be in limited circumstances. We argued that at the Supreme Court. And again, the court said very clearly that when states can show they need nationwide relief in order to remedy harms to those states, then nationwide relief is appropriate. So we will certainly assess the impact on any case. But as I sit here now, I think as it relates to states, the court confirmed what we've thought all along. Nationwide relief should be limited, but it is available to states when appropriate.
I would just add, AG Platkin, I think collectively as a group of Democratic attorney generals, we've filed well over 30 cases against the Trump administration, protecting civil rights, protecting constitutional rights, protecting funding to each of our states. But it's only been a small handful where we've asked and received nationwide injunctions. And importantly, in some of the funding cases that my colleagues have talked about, in each of those cases, the relief has generally been limited to those states that are participating in those cases. And so there might be an attempt to expand this retroactively, but given the way that we've proceeded collectively, I don't really anticipate that being a significant issue.
Let me add, it's obvious what's good for the goose is good for the gander. And we've talked about the failure of some of our sister states to act to protect their residents. But our sister states have stepped up, who are not in this case, and have filed many cases over the years, seeking nationwide relief and seeking nationwide injunctions. And going forward, they're gonna encounter some tough sledding in certain circumstances. If the president acts in many of cases that we abhor, frankly, and have opposed, there are principles that are established in those cases that now apply. So if the president acts on a major question, for example, and seeks to overturn federal law and years of practice to protect our environment. On a major question, the major questions doctrine will apply, and we will hold their feet to the fire. You know, Dobbs, there's no decision, frankly, that I abhor more than Dobbs, but that stands for the proposition that our states are sovereign, and that we can act within our sovereign authority in the best interest of people in our states. Our colleagues call it states' rights. Whatever it's called, it confirmed the right of states to act on behalf of people in our states and protect our way of life. So yeah, new laws being made, and I think it's a mixed bag, but for sure it'll have an impact on litigation going forward, and it doesn't necessarily help our colleagues in our sister states who aren't part of this coalition.
I'll take a question from David Gutman from Seattle Times.
Yeah, hello, thank you. My question is for AG Brown, and it's just kind of clarifying the consequences of this morning's decision. Absent further orders from lower courts or absent further court orders, is in 30 days, will a child born next door in Idaho to undocumented parents under this decision, are they not a US citizen? Is that your understanding?
What I would say is that their rights are tenuous. And, you know, it's a 116-page decision, I believe. So we're still analyzing the full scope of the order and analyzing the dissents as well. But if you are living in a state that did not participate in this coalition of action against the Trump administration, then your rights are in question. And I think that is explicitly clear. You know, the administration still has to go through the steps of, you know, coming up with the system that they were stayed from creating and beginning to administer, to establish the procedures by which they would start to strip away birthright citizenship as an inherent right. But in Washington and New Jersey and Massachusetts, Connecticut, your rights are much more strong. But in all those other states, including many of our neighbor states, not participating in this case is going to have consequences for the children born in those states.
Wrap up with this one final question. Sophie Nieto Munoz of New Jersey Monitor.
Hi, my question's for Attorney General Plotkin. What kind of confusion and chaos do you think that this could bring among immigrant families or mixed status families because this decision is so unclear? Like, what kind of immediate impact should these families know about or be worried about?
Well, I think the immediate message to every family in America should be that birthright citizenship is in effect everywhere. The Supreme Court said that very clearly for the next 30 days, which, by the way, is the same period of time that was in the initial order when we sued the next day. In fact, I've just been told that one of the groups of private plaintiffs have already filed a class action suit, and I suspect more will come. So I would say to everybody in America who's concerned right now, look, you have right to be concerned. The President of the United States is attacking a fundamental right in a way that has never happened in the 157-year history of this amendment. But you have people fighting for you. The folks on this call, the folks that are fighting across the country. And we're not going to stop fighting because we're right. Birthright citizenship is part of the fabric of this nation. We're going to win on that. The Supreme Court very clearly did not say otherwise today. And ultimately, when this is resolved, their rights will be vindicated.
Thank all the attorneys general for being so gracious with their time today. All the reporters, sorry we didn't get to all of you. You can follow up with the individual AG's offices if you have any additional questions. But I think we'll wrap for today. Thank you, everyone.
Thank you.